The decision in the diversity lottery litigation, otherwise known as Gomez-Acker, is really quite important for two specific reasons. One, for the first time in the modern era, a federal court judge has extended the immigrant visa usage beyond the end of the fiscal year and has reserved numbers, in a large number, over 9,000, for use in the next fiscal year for the previous year's diversity visa lottery winners. The second thing that it did that is vitally important for every type of visa applicant is it told the Department of State that a travel ban under 212F does not mean a visa ban. They still have to issue the visas to people, even if those visas cannot currently be used to enter the United States. That's important because people from other categories other than DV are being denied visas because of this ban. Department of State hasn't woken up to that fact yet, but further litigation will show them what the judge really meant. But those are two very, very important outcomes of this litigation. The most important impact for diversity visa applicants is actually that those that, one, did not finish visa processing for medical exam issues or even interview issues because they couldn't get to a consulate, will have that opportunity to get their visas. And those that had interviews scheduled in the spring that were canceled will be able to be scheduled for interviews up until the time that the Department of State uses 9,000 more visas. Now, we remain hopeful that a change in administration will enable us to go back and recapture the rest of the diversity visas. But we're excited that we've at least saved half of the diversity visa applicants for fiscal year 2020. As of right now, as far as we can tell, the Department of State is still maintaining their position that it cannot issue visas to individuals under the bans. That is directly contrary to the judge's decision, including for DV 2021 recipients. So no interview, as far as we can tell, has been scheduled for DV 2021. Within the DV 2020 litigation, the Gomez-Acker litigation, we presume the government will file a motion to dismiss, we'll file a motion for summary judgment, and the judge will issue a final decision. I believe we will win that case, and the 9,000 and change visas will then become available to DV 2020 applicants. Further from there, we have already filed as private lawyers litigation with our group of Greg Siskin and Jeff Joseph, litigation on K-1s. We're about to file litigation on O-1s. We're looking at filing additional litigation on other areas of individuals who haven't been treated fairly by the Department of State, and of course, keeping an eye on the DV 2021 lottery to make sure the Department of State is following the law as laid down by Judge Mehta. It's really important to understand that this litigation was carried out because of AILA. Because AILA hired Jesse Bless, because AILA partnered with law firms. AILA and our dues and our leadership makes this type of litigation possible and enables us as members to fight on behalf of our clients and non-clients to fix the law and make positive changes. AILA is responsible for this, and I am proud to be an AILA member.